The next topic in this area of study is criminal sanctions, and we're going to look at the purpose of criminal sanctions in particular. A sanction is the sort of legal consequence given to a person found guilty, or given to someone who's pleaded guilty to a criminal offence. These are things like prison, fines, community service. The skills you're going to need to develop relate to identification, explanation, and discussion skills. So you're going to need to be able to identify and explain the general purposes of criminal sanctions, and specifically you're going to need to explain at least 2 purposes of imprisonment. You're also going to need to discuss the ability of criminal sanctions to achieve their purpose. So for example, a question relating to that could be something like, imprisonment does not achieve the purposes of deterrence, denunciation, or punishment. Discuss. The Sentencing Act 1991 in Victoria outlines 5 aims of sanctions. So judges must give a sanction that achieves one or more of these aims, and judges need to be able to explain why they gave a particular sanction. So the 5 aims of sanctions are to punish someone, to deter people from committing crimes in the future, to protect people, to rehabilitate offenders, or denunciation, to denounce the act that someone has done. The first aim of criminal sanctions is punishment. So the offender should be punished to an extent and in such a manner that is just in all the circumstances, and so that society can feel that there's been retribution. A just punishment avoids the need for the victim of a crime to take the matter into their own hands and seek revenge. So punishment is about ideas of retribution, revenge, and feeling like the victim has been justified. A second aim of criminal sanctions is deterrence. The sanction should deter the offender or others from committing the same or similar types of offences. Sanctions are therefore aimed at discouraging other people from committing similar crimes. This is known as general deterrence, because it is aimed at deterring the general public from committing crimes. Deterrence should also be aimed at preventing the same offender from committing the same offence again. This is known as specific deterrence, in that it deters the specific person who originally committed the crime. Another aim of criminal sanctions is rehabilitation. The court will try and consider sanctions that can establish conditions which will alter or modify people's behaviour so that they will not commit those sorts of crimes again. In other words, we try and make people better, and we try and prevent them from committing those crimes by reforming them. Rehabilitation programs include things like education programs such as training offenders in trade skills, and drug dependency programs, so training people or helping people to get out of drug dependency, drug addiction behaviour. Another aim of criminal sanctions is denunciation. Denunciation refers to the demonstration of condemnation or disapproval of a particular type of behaviour. A particular punishment might be given to show the community that the court disapproves of that sort of conduct. For example, the judge might give a harsher sentence for a particularly violent rape and make comment about how the court is showing disapproval of this type of behaviour. So the aim of this goes hand in hand with deterrent. If the court denounces a certain type of behaviour, people might be less likely to do it in the future as well. Protection of the community is an extremely important aim of criminal sanctions. Sanctions should operate to protect our community against the potentially harmful actions of other people. For example, if we remove an offender from the community by placing them in jail, this can extinguish the threat of harm that they might pose to other people. However, imprisonment is usually seen as a last resort. We don't like to place people in prison if we can avoid it. Instead, non-custodial sentences, such as community correction orders, can also be seen as protecting the community from offenders because they keep offenders busy when they might otherwise be engaging in criminal activity. One potential disadvantage of using protection as a justification for criminal sanctions is that it might potentially lead to our criminal justice system being harsher on criminals than might otherwise be just. For example, under Section 6D of the Sentencing Act, a court can give a serious offender a longer sentence than might otherwise be appropriate if they're trying to protect the community from that offender. So a serious offender, someone like an arsonist, a drug user, or a sexual or violent offender, might end up serving more time in jail because the aim of that sanction is to protect other members of society from that offender. Someone else who committed a similar crime might spend less time in jail, which some might argue is unjust. However, the provisions in the Sentencing Act encourage judges to take a wider view and consider what might happen in the future when they think about criminal sanctions. When a judge sits down to sentence someone, they have to take into account a wide range of factors. First of all, they have to take into account all the aims and purposes of criminal sanctions that we just discussed, as well as a range of additional factors. However, the judge must not impose a sentence that is more severe than necessary. This principle is called the principle of parsimony. Often you'll find that the different aims of criminal sanctions will overlap, and more than one aim is being sought, or more than one aim is capable of being achieved at the same time. Further, the Sentencing Act sets out a range of additional factors that judges should consider when they're determining a sanction. It sets out maximum penalties for the offences, it sets out current sentencing practices, it sets out aggravating and mitigating factors, or in other words, factors that can make the offence worse or less bad. Examples of these include the nature and gravity of the offence, a history of prior offending, response to court orders, any mental illnesses that the offender might have, alcohol, drug, or gambling addictions, or any personal crises that the offender might have been going through. And finally, the Sentencing Act indicates that judges should consider the impact of the crime on the victim themselves. And often this is taken into account via something called a victim impact statement, in which the victim writes to the judge and expresses how the crime affected them. The next concept we're going to look at is the different types of sanctions that judges have available to them. You will need to be able to identify and explain 3 different types of sanctions as well as their specific purpose. You will also need to be able to discuss the ability of criminal sanctions to achieve their purpose. So in other words, by the end of this topic, you need to be able to tell me what are 3 types of sanctions that we have, why do we bother having them, and are those sanctions any good at achieving their purpose? The study design states that you only need to study 3 types of sanctions and their purpose. So this diagram on the right here summarizes the hierarchy of all sentencing orders, in order from most serious to least serious. At the top we have imprisonment, in the middle here we have community correction orders, and here we have various types of fines. Receiving a criminal conviction often also accompanies some other form of sanction. It is extremely serious for a person to have a conviction recorded against their name, as they then have a criminal record which can have long-term consequences. For example, it could make it much less likely for you to get future employment opportunities. The courts therefore endeavour, wherever possible, to provide a sentence without a conviction recorded, especially for young people. Here we have a table that matches up the different types of sanctions that are common up against the different purposes of criminal sanctions. So we can see, for example, that imprisonment allows judges to achieve the aim of punishing people. It allows judges to provide specific as well as general deterrence, because if you go to prison, you're less likely to want to commit that type of crime again, and if other people seeing you go to prison, well then other people are less likely to commit that type of crime. It offers protection because it locks up the offender and prevents them from offending again. It can offer rehabilitation if the offender takes part in rehabilitation or education programs inside prison, and it provides for denunciation because sending someone to prison for a certain activity is a strong message that the courts will not accept that sort of behaviour. Imprisonment is when you remove an offender from the community and thereby deny them entirely of their liberty. So it's more than just going to jail, it is considered to be the most severe sanction we have. So the Sentencing Act recognises that imprisonment should therefore be used as a last resort only. Imprisonment is our most severe sanction because, of course, in Australia we don't have the death penalty. The Sentencing Act establishes different levels of imprisonment. A minimum term of imprisonment is the time that a prisoner has to serve before they're allowed to apply for parole. For sentences of imprisonment of 2 years or more, the court fixes a minimum term of imprisonment without parole. So in other words, they're going to spend a minimum amount of time in jail before they can apply to leave jail on parole. Terms of imprisonment can be served either concurrently or cumulatively. A concurrent sentence runs at the same time as another sentence, whereas a cumulative sentence is served after another sentence, or in other words, back to back. So for example, if you're someone who has been found guilty of theft and assault, and you're sentenced to 6 months for the theft and 2 years for the assault to be served concurrently, you are only going to be detained for 2 years, rather than 2 years and 6 months. This is because the two sentences are served at the same time, or in other words, the two sentences are served concurrently. So while you are in jail doing that 6 months for the theft, you're also in jail doing the 2 years for assault. You serve them both at the same time, so once you've done the 2 years for the assault, you'll also have done the 6 months for theft at the same time, and you get to leave. Sentences are normally ordered to be served concurrently. On the other hand, a cumulative sentence is when you serve sentences back to back. So for example, if you're found guilty of theft and assault, and you're sentenced to 6 months for the theft and 2 years for the assault, served cumulatively, you would have to serve 2 years and 6 months. Or in other words, if you're serving a cumulative sentence, you have to add up the value of all of the sentences you received, and you serve all of it. Usually a cumulative sentence must be given for serious offenders, defaulting on the payment of a fine, an offence by a prisoner, or an escape offence, so if you've attempted to escape prison, or an offence committed by a person released on parole or on bail. Here we have a summary of the different purposes that imprisonment can achieve. So imprisonment is seen as the sanction of last resort, as it results in a loss of liberty and freedom. It removes the offender from society and can therefore act as a punishment for offending or as a protection for society. Having a prison system can lead to a safer society because serious criminals are kept out of society. Imprisonment can also act as a general deterrence in that most people would be deterred from committing a crime by the possibility that they might go to prison, and it can act as specific deterrence in that offenders will not want to go to prison again. However, because they mix with serious criminals while in prison, it may not be very effective as a specific deterrence, as evidenced by the recidivism statistics in Australia. Imprisonment may also lead to rehabilitation because of the various programs that we offer to prisoners. But it is also more likely to lead to further crimes because of the influence of other prisoners and the difficulty of getting back into a normal life after you've spent time in prison. Courts can also impose long sentences on offenders by way of showing disapproval of the acts that they have committed. So in other words, this can help achieve the denunciation purpose of sanctions. A community correction order is a flexible order served in the community which includes special conditions such as treatment and unpaid community work for a specified number of hours. The order can also include up to 3 months in jail or a fine. So in other words, this is what you might normally think of as something like community service. You don't go to jail, and instead the judge might impose conditions such as you have to go see a psychologist or get some form of treatment, and you might have to do some sort of community work. From 2012, the Community Corrections Order replaced a number of different sentencing orders that we used to have, such as intensive correction orders and community-based orders. So from then, we've had what's called the Community Correction Order. When you're in the Magistrates Court, a Community Correction Order can be imposed for up to 2 years, and when you are in the County and the Supreme Courts, you can get a Community Corrections Order for between 2 years and whatever the maximum term of imprisonment was for that offence. When you get a community correction order, you may or may not have a conviction recorded along with it. Everyone sentenced to a CCO must abide by basic conditions such as not reoffending, not leaving Victoria without permission, and abiding by any order given to you by a community corrections officer. Each CCO will also include one other optional condition chosen in order to meet a specific purpose of sentencing for that offender and for that particular offence. Some examples of these optional conditions might be the offender has to undertake medical treatment or some form of rehabilitation, or they might have to complete unpaid community work up to a total of 600 work hours. They might need to be supervised, monitored and managed by a corrections worker, or they might have to abstain from contacting or associating with particular people. Now let's consider some of the purposes of criminal sanctions that a CCO might achieve. So a CCO is a punishment because it's a demand on the time of the offender, something they probably don't want to be doing. Conditions such as curfew or alcohol conditions can also assist to punish the offender. It's a specific deterrence in that having to do work might discourage that particular offender from wanting to commit a crime in the future. It can protect society in the sense that it occupies an offender at times when they might otherwise be committing a crime. It can also help to rehabilitate because programs assist the offender to move away from criminal behaviour and they emphasise developing skills relating to good citizenship. On the other hand, imprisonment tends to emphasise fear and remorse. A fine is a monetary penalty paid by the offender to the court. Usually, the act that establishes the offence itself will tell you what the fine is for that offence. Under the Sentencing Act, fines are usually expressed in terms of levels, from 1 to 12, that refer to a number of penalty units. So for example, in 2015 and 2016, one penalty unit was equal to $151.67. By using penalty units instead of fixed monetary amounts, this enables the government to increase all fines at the same time by increasing the value of a penalty unit without having to change every single individual act. So for example, under the Summary Offences Act, a Level 9 fine of 60 penalty units can be imposed for performing a tattooing act on a person under the age of 18. Under the Sentencing Act, when determining a fine, the court has to consider the financial circumstances of the offender and the burden of any payment that might be imposed. The court may also consider any loss or destruction or damage to property suffered by the person as a result of the offence, and the value of any benefit derived by the offender as a result of the offence. If a fine is not paid by the offender can be imprisoned or ordered to do community work under a fine default unpaid community work order. Now let's think about how fines can achieve the different purposes of criminal sanctions. A fine can serve to punish the offender by requiring them to pay money to the court. It could act as a specific deterrence in the sense that the offender might be deterred from reoffending because they're afraid of having to pay another fine again. Or members of society might in general be deterred, or in other words, general deterrence, because they will see this person being punished with a fine and they won't want to have to pay a fine in the future. A court could give an extremely high fine as a way of denouncing a particular crime and showing disapproval of that type of activity. However, a fine is fairly unlikely to help in terms of rehabilitation of an offender, as it doesn't restore the offender to a better condition in any way. It also doesn't take the offender out of society and therefore doesn't really protect society from what they've done or the offender. Sentencing reform is a key area in the study design that you're going to have to know about. The study design tells you that you're going to need to know the following key knowledge. You're going to need to know recent changes and recommendations for change in the legal system designed to enhance its effective operation. In other words, this means that you should be able to explain a recent change or recommended change to the legal system and discuss how this could improve the effectiveness of our legal system. Because the definition of what is recent is going to naturally change as the years progress, we're going to do a specific activity on this in class. The final topic that we're going to cover in this PowerPoint is evaluating the effectiveness of criminal procedure. When evaluating criminal procedure, what you want to do is assess how effective it is in terms of achieving the three elements of an effective legal system. Now remember that the three elements of the effective legal system were having a fair and unbiased hearing, for one. Secondly, providing timely resolution of cases. And thirdly, providing access to justice. For each of these three elements, you should consider the different processes and procedures that can help achieve that element. You should consider the processes and procedures that can hinder the achievement of that element. And finally, you should consider any recent changes and recommendations for change that could help achieve that element. Let's start with the first element of an effective legal system, the entitlement to a fair and unbiased hearing. Here we have a number of processes that can help achieve that element of justice. For example, bail helps to uphold the presumption of innocence, as an accused person is generally released from custody until their hearing or trial. It also gives the accused and their legal representation the best chance to prepare their case, thereby having the same opportunity to do so as the prosecution. Committal proceedings enable the accused to learn of the prosecution's case, which helps them to prepare their defense and puts them on equal footing with the prosecution. Police investigation and police powers of questioning, arrest, and searches are balanced against people's individual rights, such as the right to silence, questioning for only a reasonable period of time, and the right to contact a legal representative or friend. This is done in an attempt to balance rights and to make sure people are treated equally and fairly by the police. So each of these three procedures contribute to having a fair and unbiased hearing when you finally get to trial. The role of the judge can also contribute to having a fair and unbiased hearing. The judge's position as an independent and impartial arbitrator ensures that the matter is heard before someone who's not going to be biased against either party, and can adjudicate on the matter, if there is no jury, in a fair and impartial way. The rules of evidence and procedure apply to both parties to a case and help to protect the accused. The parties are able to examine their witnesses, and each side has equal opportunity to cross-examine witnesses brought by the other side. The rules of evidence ensure that both sides are treated equally before the law, and to enable the smooth and efficient running of a case. The rules of procedure help to ensure the reliability of the witnesses and to get at the truth of the matter so that the court can make a decision. Consistency in sentencing can also help to achieve a fair and unbiased hearing. So the judiciary aims to be seen as totally independent of all prejudices and therefore able to treat everyone who comes before it according to the facts of the case alone and not according to any preconceived ideas or bias. The Sentencing Act aims to provide consistency in sentencing for the same reasons. The Koori Court can hear guilty pleas with the assistance of Indigenous elders or respected people in an attempt to provide a fairer, more culturally sensitive outcome for Indigenous offenders. There are, however, a number of processes that may potentially hinder entitlement to a fair and unbiased hearing. For example, bail and remand. An accused person may not be granted bail and instead be placed on remand, even though they have not been found guilty of a crime. However, if bail is given too freely, an accused person might abscond or run away, thereby causing extra work for the police and potential danger to the community. So you have to balance the opportunity for a fair and unbiased hearing against the danger that someone might run away. Inequality in resources available to each party can also prevent or hinder entitlement to a fair and unbiased hearing. Prosecution evidence for a case is gathered by the police, who are experts in this area, and they have lots of time and resources devoted to this purpose. An accused person, however, usually has limited resources and expertise in gathering evidence, and therefore it puts the parties on unequal footing. However, this is somewhat mitigated by the fact that the prosecution has the burden of proving each case. Changes to the Sentencing Act, such as tougher sentencing laws, such as those put in place in 2011 and 2013, create a substantial amount of changes to the sentences that can be imposed by courts. Home detention, intensive correction orders, and suspended sentences, for example, have been abolished. This has caused concern among some members of the judiciary, believing that the sentencing regime is too rigid and does not adequately take into account the individual circumstances of each offender. This can potentially result in an unfair outcome if we have situations where a judge is not able to be flexible and consider each offender appropriately. Now let's look at some recent changes to our legal system that attempt to provide a fair and unbiased hearing. Firstly, let's look at the County Koori Court. This 4-year pilot program of the Koori Court began operation in 2009, and in 2013, it was introduced to the Melbourne County Koori Court. This extension of the program follows along from the success of the Koori Court divisions in the Magistrates Court and the Children's Court, which has succeeded in reducing the recidivism rate of Indigenous offenders. The County Koori Court is a sentencing court for Indigenous offenders who have pleaded guilty to a crime within the jurisdiction of the County Court, other than sexual offences or family violence offences. The aim of this specialist court is to provide a more culturally relevant and appropriate justice to Indigenous offenders by involving Indigenous elders and respected people. This system tries to recognise the disadvantage experienced by Indigenous people when they are dealing with our criminal justice system. On this slide we have a proposed recommendation for change in our legal system. And this proposed recommendation is increased funding for Victoria Legal Aid. Following various unsuccessful applications for legal aid in criminal trials in 2012 and 2013, which led to trials being stayed, or in other words, postponed, there's been a greater call for more funding for legal aid. These calls for funding intensified following significant budget cuts to legal aid in 2015. Legal aid has now announced it is in talks with the courts and lawyers in order to determine how jury trials might be funded in the future. An increase in funding could help to achieve a fair and unbiased hearing by ensuring litigants have access to adequate legal representation. It also ensures effective access to the legal system, since legal aid's mission is to provide access to justice to marginalised and economically disadvantaged Australians. The second element of the legal system is access to the legal system, and here are a number of processes that can help with that. Courts are available for all to use in criminal matters, with courts in both metropolitan as well as regional areas. Courts are specialised in terms of the types of cases they hear. For example, the Magistrates Court hears summary offences, while the Supreme Court hears serious criminal offences. Accused people are able to get assistance in a court hearing from legal representatives. Therefore, because courts are available for a wide variety of matters, in a wide variety of regions, and allow people to get assistance, this can help people to access our legal system more effectively. The system of appeals means that if an incorrect or unfair decision appears to have been made, then either party is able to appeal the decision, provided they can establish reasonable grounds. Legal aid and community centres such as Victoria Legal Aid can offer legal advice and representation to people charged with criminal offences. This allows a wider amount of people to access our legal system. Unfortunately, however, there are a number of processes that can hinder access to our legal system. Distance and transport can affect your access to face-to-face legal services, and regional citizens often need to seek legal assistance outside their own community, either due to conflicts of interest or simply because there's a lack of available expertise. Further, people in the community need to know their legal rights if they want to have effective access to the legal system. The accused might be unaware of their rights, such as the right to silence, or of the legal bodies available to provide advice, including community legal centres and Victoria Legal Aid. This problem can only get worse if there are other language or cultural differences that prevent people being aware of their legal rights. Financial constraints can also prohibit access to the legal system. As we all know, legal representation can be expensive. It might be possible for them to obtain legal assistance through legal aid, although this is always means tested and subject to assessment for merit and reasonableness. Further, legal aid has limited funds, so there are many people who simply don't get assistance. A recent change that has improved access to the legal system is the establishment of Justice Connect. Justice Connect was formed when the Public Interest Law Clearinghouse, otherwise known as PILCH, in Victoria and New South Wales merged in 2013. Justice Connect works with 50 law firms and thousands of lawyers to provide pro bono legal services to those in need. Justice Connect is financially supported by its members, which are various law firms and other legal bodies in New South Wales and Victoria, the government, and by donations. Justice Connect aims to connect people who are in need of legal support by referring them to their member lawyers. A recommendation for change in this area is funding for community legal education. Victoria Legal Aid, in its 2014 submission to the Australian Law Reform Commission about equality, capacity and disability in the Commonwealth, noted that community legal education is a core way of preventing people from needing to access legal services. Legal Aid has also noted that funding is important to ensure that this legal education can be provided. The final element of an effective legal system is timely resolution of disputes. And in this slide, we're going to look at the processes that can help with that. Committal proceedings ensure that the accused does not have to wait a long time for a trial when there is insufficient evidence to support a conviction against them. This also results in the superior courts not being clogged up with cases that are never going to succeed, which saves our legal system both time and money. The hand-up brief method of committal hearing has resulted in fewer trauma for the accused and the victim, as there is not an open court hearing for the committal. It also frees up the court's time for other matters. Time limits set by the Criminal Procedure Act can also help with the timely resolution of disputes. For example, a hearing for a summary offence or an indictable offence heard summarily must commence within 12 months, unless the DPP and the accused consent to an extension of time. Some processes that hinder the timely resolution of disputes include the collection of evidence process, where police may experience difficulties collecting evidence or locating witnesses, or suspects might refuse to cooperate. Committal proceedings can also add to the delay experienced in some cases. This has resulted in some legal bodies calling for committals to be abolished. Resources have not kept pace with the growth of cases in the courts, causing problems such as cases dismissed from the Melbourne Magistrates Court due to a lack of available police prosecutors. The median time taken to finalise criminal appeals against sentences is 6 months. The Magistrates Court has a huge workload, and in 2012 to 2013, for example, it was 175,000 plus cases, but the percentage of cases finalised within 6 weeks has remained steady at about 88%. All courts have a backlog of cases which have been continuing for more than 24 months. So in other words, the huge backlog of cases and the huge workload in front of our courts can sometimes prevent the timely resolution of disputes. One recent change that has attempted to target the timely resolution of disputes is the Weekend Bail and Remand Court. In 2013, the Magistrates Court introduced a pilot program which involved hearing bail and remand applications on the weekends in the Melbourne Magistrates Court. The pilot program is currently confined just to metropolitan Melbourne. The weekend settings are intended to reduce the backlog of cases during the week and allow the accused to be brought before the court at the earliest possible time. The Weekend Bail and Remand Court also improves access to the legal system since it is easier for people to attend the court outside of work hours. A recommendation for change in this area is the expansion of the weekend pilot program. The operation of the Magistrates Court Weekend Bail and Remand pilot program could be further extended to other locations outside of metropolitan Melbourne. This might enable greater speed in dealing with these types of applications.